So our job today is to kind of pull out the key pieces for you, help you quickly grasp, okay, who exactly are we talking about here? What can creditors do? What are they absolutely not allowed to do? And maybe most interestingly, some really unexpected ways the system handles default. We're after those core insights.
Okay, yeah, let's start right there at the beginning. When this standard says defaulting debtor, who exactly fits that description? And maybe just as important, who doesn't fit? Because that seems like it sets the stage for everything else.
That's definitely the place to start. The precision here is, well, it's crucial. The standard mainly goes after the solvent defaulting debtor. So think of someone who actually has the money to pay, but is choosing to delay, to procrastinate.
Okay, so ability to pay is key.
Absolutely. It also covers the solvent defaulting guarantor.
Yeah.
Same idea, someone who backed the loan can pay it, but is also dragging their feet. And then there's a third, quite specific category, a contractor, maybe someone building something or supplying goods, who delays the work and ends up owing money because of a penalty clause agreed upon in their contract.
Right.
Now, who it doesn't cover is just as critical for understanding the boundaries. It specifically excludes the bankrupt debtor, that's al-Madin al-Mufalis, someone officially declared bankrupt.
Makes sense.
It also doesn't apply to the insolvent debtor, al-Madin al-Musir. This is someone who genuinely, truly cannot pay, maybe due to hardship, even if they haven't gone through formal bankruptcy. And very importantly, if someone delays payment because of a legitimate Shari'ah-compliant excuse, something unforeseen and valid within that ethical system, they're not considered a defaulting debtor under these rules either.
So it really is sharply focused. It draws a clear line, it seems, between people who can't pay, maybe through misfortune, and those who have the means but simply won't. That emphasis on intent and capability, not just the fact of being late, that feels like a really different starting point, doesn't it?
It absolutely is. It shifts the whole perspective.
Yeah.
You're not just looking at a missed deadline, you're looking at the debtor's capacity and potentially their intention.
Right.
And for creditors, it means the approach isn't designed for someone in genuine financial distress, but for someone, well, deliberately holding back payment they could make. And that precision is what allows for the specific kinds of remedies we're about to get into, the ones that don't rely on interest.
Okay, so let's talk about those remedies. Or maybe first the things that are not allowed. This is where it gets really interesting and maybe challenges some conventional ideas about debt.
Yeah.
What does the standard say about hitting someone with extra fees or interest just because they're late?
Yeah, this is fundamental, a real cornerstone. First off, the standard states it's forbidden for someone who can pay to default. That's seen as wrong, a breach of trust. But here's the big difference from, say, typical Western finance. It is also strictly forbidden to stipulate financial compensation, like interest or late fees, just for the delay in payment.
Wow, okay, forbidden.
Forbidden, and you can't even try to get that kind of compensation through the courts. The principle behind it is pretty profound. Debt shouldn't be a way to make more money, especially not profit from someone delaying payment. The creditor is entitled to get their original money back, yes, but not to gain extra just because time passed or the debtor defaulted.
So no late fees, no penalty interest.
Exactly. But, and this is important, that doesn't mean the creditor is just left hanging if they incur actual costs trying to get their money back. While punitive financial penalties are out, the defaulting debtor is held responsible for the litigation expenses. If the creditor had to go to court, the debtor covers those costs.
Okay, actual costs.
Actual direct costs. And also other expenses the creditor specifically incurred because they were trying to collect the debt. So maybe costs of tracking the debtor down, things like that. The focus is squarely on making the creditor whole for their actual outlay, not on penalizing the debtor for profit.
That makes sense. Covering costs versus adding penalties. But if those direct financial penalties like interest are out, what tools do creditors have? How do they actually get their money back or protect themselves? It sounds like it requires a different approach to managing risk.
It does. It requires thinking differently about security and recourse. The standard provides several quite powerful tools. For one, the creditor has the right to demand the sale of collateral. If something was pledged against the debt, they can push for it to be sold to cover what's owed.
Standard enough, I suppose?
Yes, but here's a practical twist. It's permissible to put a clause in the agreement where the debtor authorizes the creditor to sell that collateral without needing to go get a court order first. That can make the process much faster and more efficient.
Okay, streamlining it.
Exactly. Another really significant tool. It's permissible to stipulate that all remaining installments accelerate, meaning if the debtor defaults on just one payment, The entire outstanding balance can become due immediately.
Oof, that's serious.
It is. Though the standard does add a note of caution here, ideally, this should only happen after the debtor's been notified and given a reasonable chance to catch up unless, there are urgent circumstances involved.
Right, some level of process.
Yes. Now, here's something really unique, something you almost certainly won't find in conventional systems. It's permissible to include a clause in the debt contract stating that the debtor, if they default, must donate a certain sum or percentage of the debt to charity.
Wait, donate to charity.
Yeah.
Not pay extra to the creditor.
Correct. The donation has to be spent on legitimate good causes, and it's typically coordinated with the financial institution's own Shari'ah supervisory board. It's not a penalty that benefits the creditor.
That's fascinating. What's the thinking there?
Well, it serves a couple of purposes, I think. It acts as a deterrent for the debtor. There is a financial consequence for defaulting, but it doesn't enrich the creditor, which avoids the ethical problem of profiting from delay. Instead, it redirects the consequence towards societal benefit. It reinforces the idea that fulfilling obligations is important not just to the individual creditor, but kind of for the community's well-being, too. It's a really different way to frame accountability.
It really is. A financial consequence, but aimed at good deeds. Huh.
And there's one more specific remedy worth mentioning, particularly for murabaha sales. That's the cost-plus financing model common in Islamic finance.
Right, where the bank buys the item and sells it to you over time.
Exactly. In those cases, if the buyer defaults on payments or even if they become bankrupt, the seller, the financial institution, actually has the right to reclaim the specific item sold, provided it's still, in its original state. That's a powerful remedy because they can potentially recover the actual asset, not just a claim for money, which might be hard to collect.
Okay, so a range of tools there, selling collateral, accelerating payments, that unique charity donation clause, and even reclaiming the asset in some cases. Does this whole system only focus on the main person who owes the money, or does it affect others involved, like guarantors or people doing contract work?
Oh, it definitely extends beyond the primary debtor. Take guarantors, for example. The creditor generally has the choice. They can go after the guarantor or the original debtor for payment.
Flexibility for the creditor, then.
Yes, although the guarantor can put a condition in their agreement saying the creditor has to try the debtor first. But the really crucial part is that all the rules we've discussed, the prohibition on interest, having to cover litigation costs, the possibility of that charity donation clause, and even the moral penalties we'll get to, they all apply equally to a defaulting guarantor if they are solvent but fail to pay up.
So the guarantor steps fully into the debtor's shoes in terms of these consequences if they default.
Precisely. And it also applies to contractors or undertakers. The standard explicitly says it's permissible to include penalty clauses. The term is sharjazo in contracts for things like construction, muqawalat, manufacturing, istisna, or supply agreements. This basically pre-agrees a financial penalty if the contractor doesn't deliver on time or meet specifications.
Okay, so penalties are allowed in that context.
Yes, for non-performance in these types of contracts agreed upon upfront. Now, if the contractor then defaults on paying that agreed-upon penalty, then the general rules for the defaulting debtor kick in for them regarding that penalty amount. And institutions also have the right to simply deduct that penalty amount from any other money the contractor might be owed by them.
Right, offsetting it. Makes sense. Now, you mentioned moral penalties earlier. That sounds different. It's not something you usually hear about in, say, Western commercial law regarding debt. What exactly does that involve? How does it work?
Yeah, the moral penalties are a really distinct aspect, focusing heavily on reputation and trust, which are, highly valued in many business cultures. The standard gives the financial institution the right to list the defaulting debtor's name on an internal list of undesirable clients.
Okay, basically blacklisting them internally.
Pretty much. But it goes further. They are allowed to warn other institutions about this debtor if another institution asks. And maybe most significantly, institutions are permitted to directly exchange these lists of defaulting clients among themselves.
Wow, so it's not just internal. It affects their standing across the financial community.
Exactly. Think about the impact. Getting on such a list could make it extremely difficult, maybe impossible, to get future financing or even open accounts with other institutions operating under these principles. It's a powerful non-financial consequence that leverages the importance of reputation and trustworthiness in business dealings. It's like a form of commercial shunning, almost.
That's a significant lever. Definitely puts pressure on maintaining a good record. Are there other general rules that kind of round out this picture?
There are a few more worth noting. Institutions have the right to track the defaulting debtor's financial situation using legitimate legal means, of course, to monitor their transactions and basically keep tabs on their ability to pay.
So, ongoing monitoring.
Yes. And here's an interesting one. It's actually permissible for the institution to accept an increase on the debt amount from the defaulting debtor when they finally pay. Like, if the debtor voluntarily offers to pay a bit extra.
Wait, isn't that like I thought that was forbidden.
Good question. The key is the conditions. It's only okay if it was not a precondition in the contract. It's not part of some established custom where everyone expects it, and there's absolutely no collusion or prior agreement about it. Basically, it has to be a completely voluntary, spontaneous gesture of goodwill by the debtor at the moment of repayment, not something expected or demanded.
Okay, so a voluntary thank you payment, essentially, not a disguised interest charge.
That's the idea. And one last practical point. Institutions can stipulate the right to offset what a defaulting client owes them against any other money that client has on deposit with them, so they can just take the debt out of the client's account balance.
Without needing fresh permission.
Correct. If it's stipulated up front in the agreements, and if the debt and the account balance are in the same currency. If they're in different currencies, they can still do it, but they have to use the current prevailing market exchange rate at the time of the offset.
That seems like a very direct and efficient tool for the institution.
So with all these potential consequences, financial, moral, procedural role, how does the standard actually decide when someone crosses the line? When does a debtor officially become defaulting? Is there a specific trigger?
Yes. There's a clear trigger point defined. Default is formally established if the debtor delays payment beyond the specified due date, but only after a conventional demand or reminder has been issued by the creditor.
So it's not just missing the date silently. There has to be a follow-up.
Generally, yes, a demand or notice.
Yeah.
And crucially, this status of defaulting applies unless, and this is key, the debtor can actually prove they are insolvent. The burden of proof shifts to the debtor. If they're late after being asked and they can't demonstrate they genuinely lack the means to pay, they are presumed to be solvent and therefore defaulting according to the standard.
Right, the onus is on them to show they can't pay, otherwise the assumption is they won't.
Okay, wow.
Yeah.
We've really unpacked a lot there. Just to sort of recap the main takeaways.
Yeah.
We started with that very specific definition of a defaulting debtor, someone who could pay but doesn't. Then the absolute core principle, no interest or financial penalties just for delay, but creditors can recover their actual direct costs. Then we hit that really unique charity stipulation, a consequence for default, but directed towards good deeds, not the creditor's profit. And finally, those powerful moral penalties focusing on reputation and trust affecting future business. Quite a comprehensive system.
It really is. And thinking about this whole framework, the defaulting debtor standard, it does paint a picture of finance built heavily on, well, trust, clear duties, and accountability that goes beyond just the numbers. It definitely leads to a question for you, our listener, to maybe mull over. How does this system, with its focus on intent, on covering actual costs, using charity as a consequence, and leveraging reputation, how does that stack up against the debt collection and recovery systems you might be more familiar with? Are there maybe insights here about financial trust or accountability that could resonate more broadly?
Definitely some food for thought there, a different lens on a universal problem. Thanks for joining us on this deep dive today.